1.
Hello, and welcome to our webinar, May Statutory Annotations Be Copyrighted? I am Kay Warnock with the National Conference of State Legislatures. A few housekeeping matters before we begin. The National Conference of State Legislatures and the State and Local Legal Center are pleased to offer this event, which is co-sponsored by the Research, Editorial, Legal, and Committee Staff Association, the National Association of Legislative Information Technology, and the Legislative Research Librarians. NCSL did not pre-apply for CLE in any state and cannot track attendance. Those who choose to self-apply for CLE credit may. However, final acceptance of CLE hours is the prerogative of your state's CLE authority. Today's webinar is a platform for information, exchange, and engagement. Over the next 60 minutes, we encourage your participation. Please feel free to type your questions and offer your thoughts in the question box, which is just below the slides. You will not see one another's questions as they are only coming to me as moderator. Above the presentation, you will see some tabs. One is labeled Speakers, and that is a short biography of the speakers. The second is your event resources, and under that tab, you'll find a PDF of the slides and a PDF of your speaker resources and a PDF that gives you links to the actual case and all of the amicus briefs. Today's webinar is being recorded and will be available on NCSL and the state and local legal centers' websites within a week. The views expressed in this webinar do not necessarily reflect the views of NCSL or the members of SLLC. At the end of this presentation, there will be a short survey to learn your thoughts about this webinar and any topics you would like to see in the future. Since 1975, NCSL has been the champion of state legislatures. We've helped states remain strong and independent by giving them tools, information, and resources to craft the best possible solutions to difficult problems. The State and Local Legal Center files amicus briefs before the U.S. Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local governments, elected and appointed officials. NCSL is a member of SLLC, as are the organizations on this slide. Now our speakers. Max Etchemendy and Josh Johnson, both of Vinson and Elkins, represent the state of Georgia before the Supreme Court in this case. Andy Pincus of Meyer Brown wrote an amicus brief in this case supporting Georgia on behalf of the Software and Information Association. Othni Lathram is the director of the Alabama Legislative Service Agency, and Evan Powell is a senior assistant revisor with the Minnesota Legislature. Max and Josh will begin by providing us with background on this case.
Hello, everyone. This is Max Etchemendy. I'm going to kick it off by discussing the issue, a little bit about the facts of the case, and then the 11th Circuit's opinion that the Supreme Court is going to be reviewing in this case. And then after that, I'm going to turn it over to Josh, who's going to talk about the parties' arguments and the proceedings in the Supreme Court. So first, a general overview of the issue. So the basic question in the case is whether and when annotations to a state statutory codebook can be copyrighted. That's phrased a little bit differently than it is in the Certiorari petition, but that basically sums up the issue that's in front of the court right now. So first, what do we mean by annotations? Well, there are a few flavors of annotations, but generally what we have in mind are notes in a statutory code book, addressing things like providing short summaries of judicial opinions that are applying a given statute, or giving references to potentially relevant law review articles, things of that nature. So these annotations aren't part of the law, but they accompany the statutes in the code book, and they're provided to help researchers interested in knowing more about a particular statute. So what's the copyright issue in this case? Well, we can start with some common ground. Things like statutory annotations, legal commentary, and the like are all copyrightable. It's completely normal for works like this to be copyrighted. So for example, West has its own completely private annotated Georgia code, which includes text of the statutes and then copyrighted annotations produced by West, and that's sort of completely unremarkable. And more generally, you can think of copyrighted law review articles, horn books, treatises, and so on. So it's common ground that materials like that in general can be copyrighted. And there's also some well-accepted common ground about the ability and limits on government's ability to copyright their works. So at a very high level, this is copyright law all stems from the Federal Copyright Act. Copyright Act expressly forbids copyrighting federal government works. There's a special section of the statute that says works of the United States can't be copyrighted. But there's no similar provision for states. So state government works can be copyrighted. This is pretty common. So you can think of the wide range of state-produced works that might be copyrighted. State park tourist brochures or state public television programs, and myriad other works that are produced either on behalf of or directly by a state government. So that's just sort of the general layout. Now, so you might wonder, given all this common ground, why there's a copyright issue in this case at all. So we know that in general, things like statutory annotations are works that can be copyrighted. State government works, as a general matter, can be copyrighted. So you might think that annotations in a state statutory code book would be uncontroversial that they could be copyrighted. And of course, that's what we think the right answer is. But the reason this case made it all the way to the Supreme Court and why it's been controversial has to do with a series of 19th century precedents. So Josh is going to talk more about the precedents in a little bit and sort of the details of that, but essentially the Supreme Court held in a series of 19th century cases, most recent of which was in the 1880s, that judicial opinions can't be copyrighted, the actual text of judicial opinions. And lower courts extended that holding to the text of state statutes. So in other words, you can't copyright the actual text of state laws, though annotations, again, generally can be copyrighted. And so the question essentially is, what's the scope of these early precedents? So should they extend to things like statutory annotations if those annotations are official or in some sense state produced? And is there an argument for that conclusion under these precedents, kind of setting aside the text of the Copyright Act? So while we think the answer is clear, it's certainly true that lower courts applying these early precedents have had a hard time trying to decide whether those precedents should apply to various other kinds of state-produced works, things like county tax maps or privately produced model codes that are sort of incorporated by reference into state law, and so on. So, essentially, this case boils down to what do we do with these old precedents. So that's the issue, and now I'm going to turn to the facts of the case a little bit so you have a sense of how this case arose and what the fact pattern is. So lots of states claim copyright in annotations to their statutes. So it's in the ballpark of a third of the states or so, and this is discussed a little bit more in the briefs if you're interested. A lot of those states don't produce these annotations directly. They partner with private publishers to create the annotations and keep them fresh, and more generally to publish and distribute the state's official code book. So those kinds of arrangements are pretty common, and one of the states that has an arrangement like that is Georgia. So Georgia has a Code Revision Commission. That's a state government body. And the commission has a contract with Lexis, which I'm sure you're all familiar with, to produce and publish the Official Code of Georgia Annotated, or OCGA, as we call it for short. The OCGA is available in print, CD-ROM, and internet formats, and it contains both the statutory text and annotations that are written by Lexis's staff. And this is all produced under an agreement with the state, and the state actually holds the copyright. So producing the OCGA and keeping it up to date is a lot of work. So the way that Georgia can deliver the OCGA with a minimal tax footprint is to partner with Lexis, copyright the annotations, and then the way this can be supportable from Lexis's perspective is it gets to collect money for sales of books and online subscriptions. But at the same time, Georgia is committed to making the OCGA widely available, so the contract provides that copies of the OCGA will be available at places like public libraries and universities. There's a free online version of Georgia's statutes that Lexis hosts on its website. That's unannotated, but it's free to everyone and it's searchable and so on. And finally, the print version of the OCGA is price capped. So it costs about $400 for a full set, which is a pretty good price for over 50 volumes. By comparison, West's competing annotated Georgia Code is considerably more pricey. I believe it's over $2,000. So essentially, what this arrangement does is it allows Georgia to make an annotated, up-to-date code available at sort of a low tax footprint, and it does this through its arrangement with Lexis's staff, and copyright is an important part of that. So the respondent in this case, public.resource.org, or PRO for short, is a nonprofit corporation that makes legal texts available online. And it's run by a gentleman named Carl Malamed. I think it's fair to say he's a bit of a copyright activist. So PRO scanned and posted the OCGA online, which is something they've done with some other state codes as well. And when Georgia asked them to stop, they refused. So the parties end up in litigation. The case proceeds in federal district court in Georgia, and Georgia wins in the district court. So the district court ruled that the law isn't copyrightable. That's essentially how the district court read these old precedents that I referred to earlier. But the court said, well, the OCGA annotations aren't the law. In fact, Georgia statutory law specifically says the annotations are not part of the law. So since PRO copied all of the annotations, scanned them, put them online, it violated Georgia's copyright, and it had to stop. So QED, fairly simple resolution. PRO appealed, and the 11th Circuit reversed. So what did the 11th Circuit say? Well, the 11th Circuit acknowledged that the issue was difficult and that other courts had struggled with the so-called government edicts doctrine, which is a shorthand for the doctrine established by these old precedents, saying that certain state works like judicial opinions aren't copyrightable. And courts have had a hard time figuring out the scope of this government edicts doctrine, the rule established by those old precedents. The 11th Circuit acknowledged all of this, said, other courts have had a hard time with this. It's a hard case for us too. So the 11th Circuit resorted to what it called first principles about the nature of law in our democracy. Not something you see in every court of appeals opinion, I must say. And the court essentially held that certain works that aren't actually the law can still be sufficiently law-like to be uncopyrightable. That was the 11th Circuit's word, sufficiently law-like. So what makes a work law-like, even if it's not actually binding law, like a statute or a holding in a judicial opinion? Well, the 11th Circuit adopted a three-factor test that it came up with to decide which works are sufficiently law-like to be uncopyrightable in its view. And this three-factor test was based on what the 11th Circuit saw as features that make the law what it is. And the three features that the 11th Circuit decided were important and form the three factors or prongs for this test are, first, who created the work? Second, is the work authoritative? And third, what's the process by which the work was produced? So the 11th Circuit adopts this test, it applies this test to the OCGA, and its conclusion was that no part of the OCGA, not even the annotations, was copyrightable. Now, the Court of Appeals didn't say exactly which of these factors influenced it the most, but it found it relevant as to the first factor, that the state was, in its view, the, quote, driving force behind producing the annotations. I mean, this was all done under, an agreement with the state. So even though the annotations are written by Lexis as a practical matter, the court decided that it would, essentially deem the state the creator of this work. It also thought that the annotations are authoritative, at least in some sense, because even though they're not the law, they don't have sort of independent legal force. They are merged in one official publication alongside the text of the statutes that are binding law. And the court said that this would lead people to give the annotations in the OCGA a special weight, or consider them authoritative in a way that private annotations, say West's similar annotations in its Georgia annotated code, wouldn't be. So it thought that the authoritativeness factor also cut against copyrightability. And finally, the Court of Appeals concluded that the annotations are produced in a sort of a law-like way, because even though they aren't individually adopted as laws, or sort of go through the usual legislative process, and in fact aren't laws at all, the state had still legally adopted the annotations by statute as part of its official code book, and that made them more law-like. Sufficiently law-like to be not copyrightable in combination with these other factors. So the Court of Appeals ruled against Georgia, and Georgia sought review in the Supreme Court, and here we are. So with that, I will turn it over to Josh, and he can talk about the parties' arguments and where things go from here.
Great, thanks, Max. So what do the parties in the United States as amicus supporting Georgia argue? I'll start with Georgia's arguments. Georgia argues that the OCGA annotations copyrightability follows straightforwardly from the Copyright Act's text and from precedent. So starting with the text, the Copyright Act expressly provides that annotations are copyrightable derivative works. That's sections 101 and 103 of the Copyright Act. Nothing in the Act supports stripping the OCGA's annotations of protection merely because they were prepared by a contractor working on behalf of a state agency. Indeed, Section 105 of the Act specially exempts works of the United States government from copyright protection, but the Act contains no similar exclusion from copyright protection for state government works. Regarding the history of the Copyright Act, Congress, in enacting the 1909 Copyright Act, rejected a proposal to exclude from copyright protection any publication of any state government. So that proposal would have achieved what PRO argues here, that things like the OCGA's annotations are not copyrightable, but Congress rejected that proposal back in 1909. In addition, a 1959 study written by a Copyright Office staff attorney recommended against withdrawing from the states the privilege of copywriting materials prepared by state government employees, including annotations. That study was drafted and prepared in the run-up to the preparation of the modern Copyright Act of 1976. And then that 1959 study became the basis for a section in an influential 1961 report by the Register of Copyrights that recognized that states relied on copyright protection to induce private publishers to print and publish state government works at the publisher's own expense. That's exactly the type of arrangement that Georgia has with Lexis. As for precedent, Max mentioned the 19th century Supreme Court decisions that much of this case revolve around. Those decisions are Wheaton, Banks, and Callahan. Wheaton is the first of the cases. It's from the Marshall Court back in 1834, and it involved a copyright dispute between the Supreme Court's first official reporter, Henry Wheaton, and its second official reporter, Richard Peters. So as I like to say about this case, it's a great case for appellate or Supreme Court nerds, because one of the key cases in this case is a dispute between the first and second official reporters of the Supreme Court. So in Wheaton, the second official reporter, Peters, created a condensed version of the Supreme Court's prior decisions, and in publishing that condensed report, he included annotations that Wheaton had authored. Wheaton sued for infringement. The court's decision in Wheaton mostly focused on issues that aren't relevant to Georgia's case, but the opinion's last sentence stated, "It may be proper to remark that the court are unanimously of opinion that no reporter has or can have any copyright in the written opinions delivered by this court, and that the judges thereof cannot confer on any reporter any such right." I think this goes to what Max was saying earlier about how these 19th century decisions were written in a different style than modern Supreme Court decisions. You wouldn't expect in a modern Supreme Court decision to have this sentence tacked on at the end of a decision without any additional explanation, but there it is, and it is the seed of what became the government edicts doctrine, that certain government works that resemble the law are not copyrightable. But despite making this statement, the court in Wheaton remanded for a trial on whether Wheaton had complied with the statutory formalities required to perfect his copyright claims. And as the court later recognized in the case Callahan, the remand indicated that Wheaton could have a copyright in his own annotations, because otherwise there would have been no point in a remand for further proceedings. The court, if Wheaton could not have a copyright in the parts of his reports that he had written, the court could simply have remanded for entry of judgment in Peters' favor rather than a jury trial, which is what ended up happening. As a side note, I would highly recommend for anyone who's interested in the history underlying Georgia's case and Wheaton that you read Craig Joyce's articles about the Wheaton decision that are cited in the parties' briefs. The articles contain a lot of interesting facts. For example, Wheaton and Justice Story were roommates, and they collaborated on some annotations and appendices that ended up in Wheaton's reports. And then Justice Story was on the court when the court decided Wheaton. And not only that, before the court issued its opinion in Wheaton, Justice Story met privately with Wheaton and Peters to try to broker a settlement to the dispute, not the sort of thing that you would anticipate happening today. The Supreme Court returned to the government edicts doctrine in two decisions decided in 1888, Banks and Callahan. Banks held that the Ohio Supreme Court's opinions, as well as accompanying syllabi and statements of the case written by judges, were not copyrightable. But importantly, all of the works that Banks held were not copyrightable were actually written by judges, not a separate court-appointed reporter. Explaining the rationale for its decision, Banks said that the whole work done by the judges constitutes the authentic exposition and interpretation of the law, which, binding every citizen, is free for publication to all. Turning to Callahan, which was decided 1 month after Banks, the court in Callahan held that annotations authored by the Illinois Supreme Court's official court-appointed reporter, not by the court's judges, were copyrightable. So this is in distinction to Banks, where the court said that certain works written by judges were not copyrightable. Callahan clarified that when an official court-appointed reporter writes his own annotations to opinions, they are copyrightable. So Georgia reads Wheaton, Banks, and Callahan as collectively holding that while judicial opinions are not copyrightable, annotations added to opinions by a court's official reporter are copyright eligible. Similarly, Georgia argues that while statutory text is not copyrightable, statutory annotations are copyrightable, like the statutory annotations in the OCGA. So what do the United States and PRO argue? The United States supports Georgia's bottom line position in this case that the OCGA's annotations are copyrightable, but the United States reads Banks a little differently than Georgia does. It reads Banks as establishing that works created by judges in their judicial capacity are not copyrightable. And based on that reading, the United States reasons that similarly, works drafted by legislators in their lawmaking capacity are not copyrightable. So the United States argues that the OCGA's annotations are not created by legislators operating in a lawmaking capacity, and for that reason, they are copyrightable. As for PRO argues that legal materials adopted by or published under the authority of the state are not copyrightable. And for what Georgia thinks about that standard, I would refer you to our reply brief, which we filed on Friday. So what are the possible outcomes in this case? The court could affirm the 11th Circuit's decision that the entirety of the OCGA is an uncopyrightable government edict, in which case the litigation would be over. The court could alternatively reverse the 11th Circuit's decision, holding that the OCGA annotations in which Georgia claims copyright are not uncopyrightable government edicts. In that case, there would presumably be further proceedings on remand with respect to other defenses that PRO raised below and are not at issue before the Supreme Court. Finally, the court might articulate an entirely new standard for determining whether a work is an uncopyrightable government edict, and then it might remand for the 11th Circuit to apply that test to the facts of this case. So finally, I want to talk a little bit about why we think that the Supreme Court might have granted review in our case. Well, this was an unusual case because PRO actually acquiesced in our request for Supreme Court review, and there were amici on both sides of the case at the cert stage that urged the court to grant review. It's very unusual to see amicus briefs filed in support of a respondent at the cert stage, because usually at the cert stage, a respondent is trying to argue that the case isn't important, it's not going to have major implications for other cases. But if you have amici who are willing to spend the time and money to put together a brief, that suggests that the issue is important. So usually respondents do not want amici filing in support of them at the cert stage, but in this case, PRO was acquiescing in cert, and so parties supporting it filed amicus briefs urging the court to grant review. So I think that that's a major reason why the court granted cert in our case. Another reason is that, as explained in our cert petition, there is significant confusion and disagreement among the courts of appeals regarding how to apply the government edicts doctrine. And also, the issue is important. The 11th Circuit's decision threatened to upend established regimes that numerous states have that rely on copyright incentives to persuade commercial publishers to assist with preparing and publishing annotated official codes. So with that, I will turn it over to Andy.
Great. Thanks very much, Josh, and thanks very much for NCSL for inviting me to participate. My role here is to talk about the amicus briefs, of which there are many. And as noted at the beginning, I filed an amicus brief on behalf of my client, the Software and Information Industry Association, which is a group of companies, software companies, but also digital publishers that put out lots of compilations of information, including some of them put out annotated codes. So first, just an overview of amicus briefs. Just to step back for a minute, as you probably know, just from following the Supreme Court generally, amicus briefs have expanded before the Supreme Court in recent years. There are many cases where there can be close to 100 amicus briefs, sometimes more in the most high-profile cases. There's rarely a case where there aren't 3 or 4 or 5 amicus briefs. In this case, it's a pretty large number. As you see, we have 27 amicus briefs. 6 of them support Georgia. 2 support neither party, which is sort of unusual, and I'll get to that in a minute. And then 19 supporting PRO. A lot of those folks, as Josh noted, filed at the CERT stage and then refiled at the merit stage. Josh talked about the U.S. government brief, so I don't want to say too much more about that. I'll say that it's the U.S. government's position on federal statutes is usually something that the court takes quite seriously, and that's especially true when the brief is filed by expert government agencies that administer the statute. And here you have both the Copyright Office and the Patent Trademark Office signing the brief, and as Josh noted, saying no copyright protection for actual sources of law and copyright protection available for materials that simply summarize or explain statutory law. So a very important position before the court. Before talking about the rest of the briefs, let me put this copyright dispute in context. As Max noted, PRO is a bit of a copyright activist, and there's generally quite a disagreement these days about the scope of copyright. Lots of digital businesses or advocates for the internet believe that, as the saying early in the days of the internet went, information should be free, and believe that there should be little or no copyright protection because they see copyright as a legal regime that makes it hard for people to access information because they typically have to pay for it. That's not a good thing, so they want copyright laws construed quite narrowly. On the other hand, the creators of works, whether you're talking about entertainment works or intellectual works like the ones we're dealing with here, say we need the economic incentives that the copyright laws supply in order to create these works. And if you narrowly limit the availability of copyright protection, those economic incentives are going to be gone, and it may be that you'll have the consequence of having the works disappear because no one will invest the money to create them. So big debate broadly in copyright, and as you'll see, that debate gets played out in the amicus briefs in this case. First of all, the briefs on Georgia's side, just to highlight a couple, SIIA is the one that I filed, as I mentioned, the Copyright Alliance, which is a broad pan-industry association of entities that produce copyrightable works in all contexts, that advocates for the necessary copyright protection to supply the economic incentives to create those works, and Matthew Bender and Company, which obviously itself is a publisher of many, many legal works, including annotated statutes. So the basic arguments here are that the government edicts exception that Josh and Max talked about, this rule that government edicts are not copyrightable, is an exception, and it should be construed narrowly and limited to materials that have the force of law. If something doesn't have the force of law, the fact that it's put out by a government shouldn't matter. It should be copyrightable. And the briefs focus significantly on the adverse practical consequences of eliminating copyright protection. As I said, the whole idea of copyright is to provide, as the Supreme Court has said in many contexts, the economic incentive and protection so that works will be created. And so one of the points we make is not just that copyright protection is necessary to create works, but that a clear rule is necessary so that someone knows ex ante, if they invest the money to create a work, the protection will be available. And that's, we say that's a strong point in favor of the force of law line, because it's pretty clear whether something has the force of law or not, and if it doesn't, then it should be copyrightable, and only those things that do should have that protection. So legal, and that's especially true in the context of legal informational works. We talk a little bit in our brief, and I know that Georgia does as well, about the economics of producing these kinds of works, which obviously require experts to review court decisions and to write annotations and for them to be checked and to be sure that they're sensible and accurate. And that's something that has to be done year after year to keep the work up to date. That's a significant investment. And so particularly in the context of legal works, where updating is critical so that the work is up to date with the law, that economic incentive and the clear line between what's copyrightable and what isn't is really quite important. And we talk a little bit about the consequences of a waffly rule or a very narrow rule of copyrightability, which would mean that governments would have to spend public funds or these works would disappear. And both of those consequences seem pretty bad for the public interest at large, and another strong reason to have a good, firm line that protects copyrightability. So let me talk for a minute about the briefs supporting neither party, because they address an issue that is not squarely before the court, but is hotly debated these days, and as to which there has been some litigation. As you all probably know, there are many private organizations that develop industry standards. Think Underwriters Laboratory, the Fire Protection Association, building codes, ASTM, the American Society for Testing and Materials, lots of privately developed industry standards that often are incorporated into laws or more frequently into regulations. Lots of housing building codes incorporate the Fire Protection Association standards. They may incorporate ASTM standards in some contexts. Other kinds of regulations may incorporate ASTM standards. Those standard-setting organizations typically fund their operations in part through the sale and licensing of their standards, which they are protected by copyright, and so the standards are only available if you pay for them. But a big controversy, what happens when a local government, either by regulation or by statute or some other government, incorporates those private standards into the law? Do they thereby become something that has the force of law? Does that make the government edict doctrine apply to them? And if it does that mean that the government that has incorporated into the law, or maybe the federal government, which says copyright protection is eliminated, has effected a taking for which the copyright owner gets compensation? These issues are being litigated in many cases, and these standard-setting organizations, I think, were concerned that the court might do something in this case that could inadvertently affect the arguments that they're making as to why their copyright protection should be maintained. So they filed a brief, a large group of them, hiring Don Varelli, former Solicitor General, in order to hope that their brief would get attention before the justices, to flag this disputed issue and to urge the court not to say anything in this opinion that addresses that issue. For example, if the court broadly said anything that has the force of law is not copyrightable, PRO and the plaintiffs challenging the copyrightability of those regulations would take that to their lower courts in which they're litigating and say, haha, the Supreme Court has said something that has the force of law isn't copyrightable. That must mean that these regulations are not copyrightable anymore because their incorporation has given them the force of law. So a big push by these groups to say please don't say anything in this decision that affects our arguments. Let them play out in the lower courts, and you can deal with them later if and when that's appropriate. As I said, many briefs supporting PRO. Internet organizations, public interest groups like the ACLU and privacy groups, law professors, the American Intellectual Property Association, media organizations, the Reporters Committee, associations of librarians generally and law librarians, former government officials, and others. Lots of different arguments in these briefs. They all argue for broad exclusion from copyrightability. Some of them nod to the 11th Circuit's test that was described earlier, but many of them take a much broader view and say, for example, that all government-created or government-adopted works shouldn't be copyrightable. Some of them say, here, because the allegedly copyrighted material is intermingled with the official code, that by itself, that intermingling should render things non-copyrightable. One of the arguments that's advanced is copyright here hinders individuals' access to the law because the online access to the Georgia Code, which is provided via a private website, just the code, not the annotations, is not enough to compensate for the fact that the official code is available only for pay because it incorporates the annotations. And there are various arguments about that, ranging from accessibility to the argument that this shouldn't be delegated, this government function shouldn't be delegated to a private entity, to the fact that the private entity could, through cookies and other means, see who's accessing the Georgia Code, and that's improper. And finally, a very broad argument that anything that's the official speech of a state should not be copyrightable. So as you can see, some of these arguments urge the court to go far beyond where the 11th Circuit went in its decision and to broadly do something to limit the copyrightability of state-produced materials. It seems pretty unlikely that the court is going to do that, given the narrow question presented here and the pretty strong indication both in the history that was described earlier, but also in the history of the fact that there are lots of states that have copyrights and have for many years. Seems pretty unlikely that the court is going to go that far, but it is an indication of the focus and attention on the scope of copyright generally, but especially in the area of state-produced materials, which, regardless of what happens in this case, isn't going to go away anytime soon. So with that, let me turn to Otney for a discussion of the state amicus brief.
Fantastic. First off, let me express my gratitude for being able to participate in talking about this very important topic today. I think we've had a good discussion on the law, and I certainly don't purport to be an expert in that area. And so the bulk of my comments and remarks are going to focus a little bit more on the practical implications associated with the case and the effect of its possible outcomes. By way of background, one of the roles I play in Alabama by virtue of my position is as our state code commissioner. That function is performed under the general supervision of a committee of legislators known as the Legislative Council. We're one of those roughly third or so of the states that partner with a private publisher to produce annually an official Code of Alabama with annotations. Also, by way of background, our code, the entirety of the text of our code, is available online for free directly from the legislature on our legislative website without going to any private party website or any third-party website. I started tracking this Georgia litigation fairly early on. It was brought to my attention mainly because our contract for the official code was coming up for renewal in January of 2018. And so during that time frame, it was important for me to understand what was going on in this process and to try to pay attention to it. Because of tracking that early on, I felt like it was important for states like Alabama to weigh in as well. I worked with our Attorney General, and ultimately we decided the best route was joining with Arkansas and the 13 other states and District of Columbia that filed what I guess is styled now as the Arkansas amicus brief. That brief really covers two grounds. One is the basis under copyright law itself as to why we believe these works are subject to protection. And then secondly, kind of as I said earlier, kind of a broad category of practical considerations. I'm really only going to talk about the copyright portion very briefly, and that's to say that I think our concern is that the 11th Circuit opinion, if affirmed, and I know we had a good discussion on kind of the possible outcomes, but if affirmed, is actually much broader than what a lot of people are concerned that it would be. I, for one, when I read the 11th Circuit brief, was one of the people who, or the 11th Circuit opinion, was one of the people who thought Alabama was fairly distinguishable from some of the things that were raised about how Georgia goes about adopting its code. That was until I actually went to Georgia on other business and met with the folks who do their code and looked at, the annual bill that they pass as part of their codification process, and found that it was far more similar to what we do in Alabama and what I think is done in most states than what it seemed like the court had categorized it. For instance, the court, specifically has a sentence stating that the Georgia legislature annually adopts the annotations. Well, if you look at Georgia's annual codification bill, I don't think you will find that that's accurate, or it certainly didn't appear to me to be accurate when I looked at it. And so, there was a concern certainly on Alabama's part, and I think a number of other states, that what was going on was actually broader than the 11th Circuit opinion was being read to mean. And so with that part, I want to talk a little bit about kind of what the code contract means to us, how it benefits the state of Alabama and I believe its citizens, and what the practical implications would be if Thomson Reuters, who our contract is with, lost the ability to have a commercially viable product. First off is a tremendous level of editorial support. I know there's a lot of legislative staff on this call. I suspect most of you feel the same way that I do.
My apologies, everyone. Osney's audio has dropped for a moment. We're going to try to get him back. Just give us a couple of seconds to see if he comes back on.
Wait for a second for him to reconnect.
All right, so folks, Osney somehow got kicked off of our system, and bear with us a second. So what I'm going to do is, if it's all right, I'm going to transfer this to Evan and let him speak for a while. and then we'll go back to Osni in a moment.
Hey, Kay, I'm so sorry. I'm back on. If y'all...
Osni, you are. All right. Okay, I'm going to transfer it back to your slide. Sorry.
I'm terribly sorry to everybody. I was having a terrible beeping noise on this end. I guess y'all were getting silence. And so I guess where I dropped off was in talking about the amount of extra editorial support we get from West as part of our code publishing contract. As I was saying, we, like most states, have a fairly lean legislative staff, and each and every year we have access to multiple lawyers and editors as part of what happens with our code publishing contract that we wouldn't otherwise have access to. And while they're obviously mostly focused on the annotations and items that appear in the annotated code, they are as familiar or more familiar than anyone who doesn't work in our legislature with the code itself, and offer a tremendous amount of feedback and spot issues that otherwise, frankly, would likely get lost. And the state as a whole and all persons interested in the Code of Alabama have access to that because it finds its way to the actual code text, which again is available for free. Additionally, the code contract provides our staff and legislators with online research benefits as part of that contract that otherwise the state would have to pay for at a pretty hefty rate. So for states and state legislators that are obviously budget conscious, the level of access we have to research tools and the like is tremendously benefited from the contracts. Finally, the contracts provide for greatly reduced pricing for government purchases. And so what that means is the state of Alabama is able to distribute the code, the official code, far more broadly than it would otherwise be available, both to public officials and public employees who rely on it day in and day out to perform the functions that they perform for the citizens of the state, as well as to institutions of learning, libraries, schools, and the like throughout the state to a much greater extent than would otherwise be available if the state was having to figure out a way to publish it itself and distribute it separate and apart from that contract. So kind of in closing, I guess the point that I'd like to make is that these contracts are exceedingly beneficial to the state. They're exceedingly beneficial to the legislatures and how they go about doing their business, and ultimately to the citizens as a whole. With that, I'm going to pass it over to Evan to talk specifically about Minnesota and their perspective.
Thank you. I'd like to thank NCSL for having me. I also want to thank the presenters for their expertise and the deep background they've provided in the case. I know I've learned a lot. I plan to speak mainly about the perspective of the Minnesota Office of the Reviser of Statutes. We're not involved in the case as an amicus party, and I'll try to keep my comments short. The Reviser's Office has followed this case and started to think about copyright more thoroughly once we knew that the Supreme Court would address the issue. And our office understands that statutory code compilation and publication practices, as has been noted here, and copyright claims to code materials varies throughout the states. So the first question that came up when we started to think about this was, how are we different from states like Georgia and other amicus states, and how are we the same? So how does code compilation work in Minnesota? The Minnesota Reviser's Office is directed by law to compile and publish Minnesota statutes. The statute's publication includes editorial materials that do not have the force of law, and our office submits for federal copyright. We're directed by law to do so. A couple things to note is that the chapter of law that covers the Reviser's Office provides some general guidelines for publication and grants our office broad publication and editorial powers. I can discuss that more in a minute. And the Reviser's Office has never pursued an action for violation of our copyright. So the next question we confronted in thinking about this issue was, depending on any similarities or differences between our practices and the practice of Georgia and other states, how much attention should we give to this case? Primarily, we had a real decision on informing the Minnesota legislature on the question of would it be a benefit to Minnesota to file an amicus brief, or would it be best to wait for an outcome and determine how it may apply? So some of the concerns that rose to the top of the discussion were what the scope of the opinion would be. So generally, avoiding broad changes in the legal landscape is beneficial. It protects the status quo. But we also considered that filing a brief could help shape how the ruling could apply to states situated similar to Minnesota, as well as future cases, and clarify or continued claims to copyright. We also discussed highlighting major differences in code compilation and legislative practice. Primarily, Minnesota statutes is prepared wholly by the revisor's office here in Minnesota. It's designated as the official version, and it's not fully annotated, and our statutes are available both in print and online. And then finally, we started to think about how Minnesota's publication could be distinguishable based on the 11th Circuit opinion framework. And that's already been discussed a little bit, that framework. We started to think about the authorship and thinking about how the revisor's office prepares Minnesota statutes without supervision or ratification from the legislature. The authoritativeness of the materials. The editorial materials are not part of the law, which is provided by law here in Minnesota as well, similar to Georgia. And the process, in that Minnesota statutes is not annually enacted as an official code. So as you know, Minnesota did not move forward with an amicus brief, but discussing the case motivated us to engage more deeply with how our publication practices relate to any claim to copyright. So our focus moved on to thinking about what editorial materials are created for Minnesota statutes and what materials might be subject to copyright. As you can see there, these are some examples of editorially created materials in the revisor's office. They fall into two categories mainly, and those would be things that are kind of adjacent to the legal text, like editorial notes and legislative history and the like. And then there are things that are provided entirely separately, like tables and indexes and users' guides and other finding aids and information. So once we itemized the editorial and publication work at issue, we started to think about what broad concerns may exist outside the framework of the 11th Circuit opinion, just so we could have an understanding of when we get an opinion from the Supreme Court, what would we do with it? So thinking deeper about the justifications of the government edicts doctrine and the 11th Circuit opinion, we began to get concerned about clear access to the law. We've discussed how defending copyright protection could protect the status quo, which could be good for at least a couple of reasons. The first is that in Minnesota, we provide a product that exceeds due process notice of the law, and we hear from many users how much they appreciate the editorial materials we create in the publication. And two, we also strive to enhance access to and transparency of the law. And while we've not vigorously enforced copyright, we have become more concerned about commercial misappropriation and making sure that others don't use our publication in a way that would perhaps misrepresent the law. And we think that these considerations support the integrity of the law. And possibly without protection, it may be less clear to the public what is an official version of official and correct publication of the law, and we may only be able to provide something closer to bare due process notice. So the case and its possible outcomes and our concerns and review of our practices have led us to create an outline of the work that we believe we need to undertake in order to be prepared for whatever the future holds after the Supreme Court opinion. So what work are we undertaking? First, we want to better understand our history and current practice as it relates to statutory compilation copyright, cataloging our copyright submissions and current practices, comparing this to public data we have from other states, itemizing any possibly copyrightable editorial enhancements that the revisor's office has provided throughout editions of Minnesota statutes. We will likely be in the situation of creating some legal research documents to inform the Minnesota legislature on the decision by the Supreme Court, including additional analysis of the Federal Copyright Act and any other judicial precedent. And beyond the government edicts doctrine, looking into standards for authorship, originality, fair use, et cetera, and understanding that we may need to even examine recent changes to the Copyright Office compendium. And then finally, we want to make sure we document our practical concerns. So we would need to understand how we would continue to assert claims of copyright, if at all, based on whatever the Supreme Court opinion is. Another consideration is that Minnesota has enacted the Uniform Electronic Legal Material Act, and we need to understand how we'll move forward in understanding both our paper publication versus our electronic publication. And then as has as has been discussed already, we want to understand how any decision would affect our contractual publication relationships and plan any future publication and editorial work for the office within whatever the new legal landscape is. So with that, I will say that in conclusion, we're very interested in following the oral argument and seeing what the guidance from the Supreme Court will provide, and thank you very much.
Thank you to all of our presenters. We have a large number of questions, and I will just warn you that that we are not going to be able to get to all of them. We're going to do our best to hit as many as we can. But any of you who ask questions, if we can't get to them in this call, I will reach out to you privately. I wanted to note to you that up in your resources is a page that has 2 links that will get you to all of the amici, and I also mention it on this page. So now we're going to switch to questions, and I'm just going to start with some of the ones that I have in hand. The first question is, where does one find the Copyright Office report that talks about how states rely on copyright to publish annotated statutes? This is something that was mentioned regarding Georgia's arguments.
Yes, I'm happy to handle that. Actually, the Copyright Office website, which I believe is just copyright.gov, if you go to the main page, there is a history section on the website, and it's quite helpful. It contains a lot of legislative history materials from when the Copyright Act of 1976 was being enacted, and you should be able to find the 1959 study and the 1961 report I mentioned on that website.
Super, thank you. Here's another one. Any guess on timing? When will the U.S. Supreme Court announce a decision?
Max, you want to handle that one?
Yeah, I can handle it. So, so the case is being argued in early December. The court generally makes a very strong effort to get its opinions out for the term by the end of June when the term ends and the court recesses. So, that's not an exceptionless rule. I would be astonished if this case were held over. So, basically sometime in the first half of 2020. Very rarely do these opinions issue more than, sort of a month or 2 after argument. But, it could be as late as June. So, sometime in that ballpark, I guess if I had to make an estimate, I would probably guess, in the earlier spring. But these things are a little unpredictable. A lot of it depends on, whether there are going to be dissents, concurrences, and whatnot, because, if that happens, there's a lot more sort of back and forth writing and drafting on the court. So quite unpredictable, but first half of 2020 is pretty nearly guaranteed.
Super, thank you. So this is a question that's more of a municipal question. A court reporter's work, after recording a hearing, transcribes the hearing word for word, or even summarizes it as if writing minutes. Is this court reporter's work copyrightable?
So this is Josh. That is an excellent question. I have a vague memory that the Copyright Office compendium addresses this issue. I don't remember where the Copyright Office comes down on the issue. My gut reaction to the question is that if it is fully a factual recitation of what happened at the trial, verbatim, word for word, there may be an issue with copyright, not because of the government edicts doctrine, but instead the separate principle that facts themselves are not copyrightable because copyright requires some minimal degree of creativity. So if you are just simply reporting facts such as listing names of people and their phone numbers in the white pages of a telephone directory, that would not be copyrightable because that listing doesn't involve any creativity. And I could see an argument that a court reporter's transcription of what happened at a hearing similarly would not involve any creativity and may not be copyrightable. But that is simply a gut reaction to the question, and so it's certainly something you want to do some more research on.
Thank you. Okay, here's another question. I am in a state that doesn't do statutory annotations, but we are planning to start. Are there ways that we can create and post these annotations that would allow for copyright protections? Are there best practices to avoid this conflict?
So this is Josh. Maybe I could start with an answer and see if anyone else has additional ideas. I think a lot's going to depend on what the Supreme Court says in our case. So I think you're going to want to watch for the Supreme Court's decision, and that should provide some clarity about what, if anything, states can do to ensure that things like the OCGA's annotations are copyrightable, or perhaps the Supreme Court will adopt PRO's test, which I believe is fairly broadly worded and would make it hard for most state statutory annotations that government officials are somehow involved with writing or adopting. I think under PRO's test, it would be hard for those things to be copyrighted. So we'll see what the Supreme Court says.
This is Max. I'll just jump in and offer another point, which may not be helpful, but it'll at least be sympathetic. I think this question really highlights a point that Andy brought up, and that is sort of a high point of SIA's very helpful amicus brief, which is that this whole area of law and the whole government edicts doctrine, it's based on these early cases that are a little hard to interpret, and you've got a whole lot of different proposed standards and tests flying around because really, it's not grounded. None of these arguments that PRO is making and that the 11th Circuit adopted below, none of them are grounded in the text of the Copyright Act. And it's pretty open-ended. So, this is one of the things that makes it a little hard to predict, Of course, we would like Georgia to win, and then, in that event, hopefully there would be a lot of clarity. But beyond that, one of the reasons it's hard to know is that we've got the 11th Circuit's sort of three-factor standard, and, maybe there are some things that states could do to try and comply with that while still having a somewhat similar arrangement. There's also PRO's even broader standard. If the court were to adopt that, I would be at a loss to articulate a way to have an arrangement for some sort of official annotations where they would be still copyrightable. So hopefully the court will provide some clarity, because as this question highlights, clarity in advance is very, very important in copyright for exactly this reason. You need to know how to structure the arrangement with the publisher, and you need to know what the copyright protection will be in order to make an arrangement that will be sort of acceptable to all the parties.
Thank you. Okay, here's another one. If copyright applies, can the copyright holder refuse to comply with a discovery motion from a court when the text of the copyrighted matter is critical to the case? For example, incorporated building code in a state that does not offer an alternative to the privately produced official edition.
So this is Josh. I'm not sure if I fully understand the question, but I think the question of whether you need to comply with discovery request probably goes far beyond the question presented in our case. So I don't have a strong sense about that. It's certainly something that you'd want to consider and do some more research on, and would depend on the particular facts of the case, what the discovery request is, and if you're facing an order from a court to comply.
Thank you. So here's another question. If on the legislative floor, the legislature reads text from a published book that is a copyrighted book, does that move that actually copyrighted book into the public domain?
Josh, I'm happy to take this one. So no, I think that would be. I think that wouldn't move the work into the public domain, even under PRO's test. So the sort of the broadest standard that's in play here would essentially exclude from copyrightability government adopted or government produced legal texts. So certainly even under PRO's standard, if the text that was read wasn't a, quote, legal text, it certainly wouldn't fall within the scope of the rule. My guess would be, it's a little hard to predict how the broad rule that PRO has proposed would sort of play out in practice. My guess is that a work being read by a legislator on the floor wouldn't count as it being sort of adopted by the state, although admittedly that test is very broad, and courts would have to work out how to define its contours. My gut reaction would be that the copyright wouldn't be impacted under any of the tests that are in play, but I'm curious if Josh thinks otherwise.
The only thing I'll add to what Max said, which I completely agree with, is that the Copyright Act itself contains a section 201E, which prevents government expropriation of copyright. And I think that it would prevent copyright from being nullified in this hypothetical situation where a legislator is reading a copyrighted work, during, it's like the filibuster, and the legislature is just reading a novel during the filibuster or something like that. I think under Section 201E, that would not vitiate the copyright.
Thank you. So here's a question that's actually for Othni. The question is, does your contract provide a discount to other legal research products published by the vendor for the Alabama legislature and or state government?
No, the answer to that is it does not. The discount is limited to the code itself. That said, I discussed briefly kind of the online tools that are made available to us, for legislative staff, and in some instances legislators themselves as part of the contracts, and it is broader than the code. It includes a fuller version of West's online offerings than just the code.
Thank you. Here's another one. Is there a leading case for PRO's argument that privately adopted codes with force of law should not be protected by copyright?
Go ahead, Josh.
Oh, sorry. I think the leading case, if I'm understanding the question correctly, would be the Fifth Circuit's decision in Veek, which held that a model building code was not copyrightable insofar as it had been adopted as law by a municipality. So under the Fifth Circuit's decision, the model code, qua model code, was still copyrightable, but the model code as actually adopted as law and presented as the law of the municipality was no longer copyrightable because it was the law. So I think that VEEC would be the key precedent on that particular issue.
Thank you.
I was just going to add, this is Max, I was just going to add the Ninth Circuit's practice management decision, which was about AMA coding, might also be relevant. It's a little less on point than the VEEC decision, but that one is also about sort of private standards that are, in some way used by the government.
Thank you. So we've run over a little bit because we had so many questions, but I really appreciate all the questions, and I appreciate the panel for taking the time to stick with us for a few minutes longer. Max, Josh, Andy, Othni, and Evan, thank you so much for your time and for your information. All of the members of the audience, I really appreciate your spending some time with us today. If you have additional questions, please feel free to email me privately, and I will work with you to find the answers. Thank you for attending, and have a wonderful day. Please take a moment at the end of the webinar to complete the survey. Thank you.
Thank you.